We all encounter some inevitable events in our life, such as death. It comes uninvited. Now, what is your topmost concern when you think about this? Obviously, it is the care and well-being of your loved ones. For example, your minor child or children in your family. In one of our earlier videos, we discussed about creating this legal instrument called will, which protects your rights, fulfills your wishes, and also brings financial security to your loved ones. So today I will explain a bit more in detail regarding the contents and provisions of the will. Let's start with identifying the parties and what their meaning and functions in law is. First comes the testator. Now he is the person who writes or creates the will, because of which the identity of a testator must be accurate. You need to provide the name, age, address, the personal identification number, and whatever goes into explaining or determining the identity of the testator. Secondly, we have the beneficiaries. Now these are persons to whom the benefits of the estate will be shared with. So there is no emphasizing on how important it is. Just like the testator, the accurate information of the identity of the beneficiaries is a must, or else you know what can happen, and that is conflicts and disputes will be the consequence. Also, one needs to take note that if there is a minor, you need to appoint a guardian and provide the identification detail of the guardian. Thirdly, we have the executor. An executor is a person appointed by the testator who will execute and implement the wishes of the testator. He will supervise and oversee the distribution of assets and liabilities. A trustworthy, loyal person whom the testator is confident with must therefore be appointed. Lastly, we have some more important persons, and those are the witnesses. A deed which is signed in the absence of a witness or the signature is considered invalid. So if you have identified the parties involved and what their roles, functions, and responsibilities will be, you can go ahead and then make your declaration clause. Now, what does this contain? It simply declares that as a testator, you are of sound mind and in your own free will have decided to distribute the assets. You should also declare that this is your last and final will. But having said that, if you have prepared earlier or you have previous wills, then you need to incorporate a revocation clause, which states that your earlier wills stands revoked and cancelled. With this in place, we move on to the list of assets. By now, you would have a fair idea about what are the assets that you wish to distribute. Your real estate, your personal property, your bank accounts, shares, stocks, digital assets, and so on. So once you have listed them out, next you divide and allocate the share of each to your beneficiaries. You need to bear in mind that it is as detailed, your intentions are as detailed as possible. It must show clarity. If you are able to fulfill or comply with most of these requirements of the provisions, then you move towards the conclusion of a basic will, which is obviously the signature of the testator and the witnesses. It has to be signed, witnessed, and attested by the required number of witnesses. One must also bear in mind that the beneficiary or the spouse of the beneficiary cannot be witness to the will. So this is a brief understanding of what is incorporated into the will. And if you have any further questions or comments, you may please ask them in the comments section. Please watch our future videos on other alternative ways in which we can share your assets.